calling the regular Fairfield Planning Commission on July 27, 2022 in order. Mr. Feinstein, may we have the roll call, please?
Yes, and before I conduct the roll, I do want to note that we have two new commissioners that I'll be calling their names this evening, taking the place of Commissioner McDonald and Commissioner Smith. So with the roll call, the first person is Commissioner Paul. Is present. Commissioner Greavy?
Present.
Commissioner Werblin? Maybe on Zoom. Commissioner Werblin, are you with us?
Present.
Commissioner Evans?
Present.
Commissioner Cruzen?
Present.
Commissioner Childs? Present. And Commissioner Matthews?
Present. Commissioner Paul, as your first act, may we ask you to lead us in the Pledge of Allegiance? Pledge allegiance
To the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Okay, regarding public comments, persons wishing to address the Planning Commission on subjects not on the agenda but within the jurisdiction of the Planning Commission may do so, provided that no action will be taken on off-agenda items except as authorized by law. Off-agendized items from the public will be taken under consideration without discussion by the Commission and may be referred to staff. Comments will be accepted in person or via Zoom. Those wishing to speak on agenda items in person, please complete a green speaker card and bring it to the front desk before the meeting or at the latest prior to the time for public comments on that item. When joining via Zoom, please use the raise your hand feature or press *9 on your phone to request to speak. You'll be called on by name and have 3 minutes to speak. Next, we have approval of the agenda. Are there any changes to the agenda?
There aren't any changes.
May I have a motion to approve the agenda?
I make a motion that we approve the meeting agenda.
And a second? Mr. Feinstein, will you conduct the roll call?
Yes, Commissioner Paul? Commissioner Greavy? Commissioner Werblin?
Yes.
Commissioner Evans?
Yes.
Commissioner Cruzen?
Yes.
Commissioner Childs?
Yes.
And Commissioner Matthews?
Yes. Okay, the next item is approval of the minutes for the June 22nd, 2022 Planning Commission's meeting. Are there any changes to the minutes? If not, may I have a motion to accept?
I make a motion that we accept the June 22nd minutes.
And a second?
A second.
Commissioner Werblin, second.
Thank you. Mr. Feinstein, please conduct the roll call vote for the minutes.
Yes, and our two new commissioners were not on the commission, so I think they have to abstain. Commissioner Werblin?
Yes.
Commissioner Evans?
Yes.
Commissioner Cruzen?
Yes.
Commissioner Childs?
Yes.
And Commissioner Matthews?
Yes. Okay, now we are moving into the public comment period. This is the time for the public to speak on items not on the agenda but within the jurisdiction of the Planning Commission. I now open the public comment period. I see no one ready to speak. Is there anyone on Zoom?
We have nobody on Zoom.
Okay, I now close the public comment period. Moving on to scheduled matters. For each item on the agenda, there will be a presentation by staff. For items that involve an application request, The applicant will be asked to address the commission if they so desire. The public comment period will be open via Zoom and in-house. After comments are been made, we will close the hearing and consider the testimony and comments that have been asked. After the comment period is closed, the commission will deliberate on the item and may have additional questions for staff. We cannot take any additional testimony or questions from the public after the comment period is closed. The first item A is election of chair and vice chair for the fiscal year 2022 through 2023. So do we do the chair first and then the vice chair?
Correct, yeah. You
Okay.
take any nominations or volunteers for
So
the
are
chair?
there any nominations for the chair for the coming year?
I'd like to serve as the chairperson for fiscal year 2022 through 2023.
Okay, any others? So do we take an actual vote?
You do take a vote, so roll call vote.
Okay. Go ahead.
Okay. So on the nomination of Vice Chairman Childs to be the chairman for the Planning Commission for the coming year, I'll take the vote. Commissioner Paul? Yes. Commissioner Greavy? Yes. Commissioner Werblin?
Aye.
Commissioner Evans?
Yes.
Commissioner Cruzen?
Yes.
Commissioner Childs?
Yes.
And Commissioner Matthews?
Yes. Next, we have nominations for the vice chair.
I'd like to nominate myself for the vice chair.
Okay. Are there any others? Failing to hear, please conduct the roll call vote for vice chair.
Okay, and I apologize. Commissioner Cruzen, you were volunteering for the vice chair?
Correct.
Okay, all right. For the nomination of Commissioner Cruzen as the vice chair, Commissioner Paul? Yes. Commissioner Greavy? Yes. Commissioner Werblin?
Yes.
Commissioner Evans?
Yes.
Commissioner Cruzen?
Yes.
And Commissioner Childs?
Affirmative.
And Commissioner Matthews?
Yes.
Okay,
Do we make the change now?
we don't do it tonight, so at the next meeting, the new chair and vice chair will take the seats.
Okay.
All right.
Congratulations. The next item is item B, a training on development permitting and the California Environment Quality Act by Assistant City Attorney Ethan Pawson. Please go ahead.
And before Ethan begins, the presentation that you see here, we'll send a copy off to you after the meeting, so you'll have that to refer to after the meeting.
Yeah, quick question. I never met Ethan before. Do we get an introduction or?
Sure, if Ethan would like to introduce himself, but before he does, as you all know, Casey Strong, our longtime city attorney for the Planning Commission, who's no longer with Richards, Watson, and Gershon, our city attorney firm. Ethan is going to be taking over many of Casey's duties. So, Ethan, you want to introduce yourself a little bit?
Thank you. Pleasure to meet you all. My name is Ethan Pawson. I work as an associate at Richards, Watson, and Gershon, and I'm an assistant city attorney here in Fairfield. I grew up in the Bay Area out in Sonoma County, and I'm really excited to be working with Fairfield on a number of matters, and it's a pleasure to meet you all, and yeah, excited to provide this training about kind of community development and CEQA as it applies to your decision making. All right, so without further ado, just a brief overview of what we're going to cover tonight. First, we're just going to have a general discussion of the history and the role of zoning policy and how it's come to in its current form today. Second, we're going to talk about the different types of land use hearings that come before your commission and the types of decisions that you make in those hearings. Third, we'll talk about drafting findings and conditions of approval when you're approving projects or in the case of denying projects, how to make those modifications. And fourth, we'll do a brief primer on CEQA. We may have another training in the future to kind of get more into the weeds on CEQA, because obviously there's a lot to be said there. But this will kind of just, especially for our new commissioners, give you a general understanding of what the California Environmental Quality Act stands for. So this should look somewhat familiar to most of you. This is the zoning map for City of Fairfield, and it kind of guides how developments get approved and what types of uses are possible throughout the city. So just a bit of history on zoning. Zoning is an element of the police power under the California Constitution. The police power generally refers to the idea of local governments being able to regulate things within the general welfare for health, safety, morals, peace, these ideas that are kind of not necessarily always regulated or legislated on at the state and federal level, but are left open to local governments to be able to control with their local policy. Next, so zoning is part of the police power, and the first case that kind of comprehensively upheld a zoning policy came out of Ohio, and the Supreme Court in 1926 ruled that the village of Euclid could have a comprehensive zoning policy for their city. Euclid's a suburb of Cleveland, and at that time Cleveland was rapidly expanding to have a lot of industrial uses, and this was a more residential area outside the city limits where they incorporated a city and decided that they wanted to regulate and not allow as many industrial uses into their city. And so the property owner here owned a portion of land that crossed over several zoning districts, and the way their zoning policy worked, it was just a progressively permissive zoning policy. So in Zone 1, it was only residential. Zone 2 allowed some assembly, church, school type uses, all the way up to Zone 6, which allowed all uses, including heavy industrial and that sort of thing. And so obviously the most permissive zone was the most valuable land, and so the property owner argued that it was a taking of his property rights by regulating the land in that way. But the Supreme Court said that this was within the police power of the city of Euclid. They could regulate use of land in that way. And ever since then, most cities, all cities, I believe, have a zoning ordinance that kind of controls where zoning policy or where uses are allowed and where they're denied. Zoning history also has kind of a darker history in our country. In 1917, the Supreme Court ruled that race-based zoning was unconstitutional under the 14th Amendment Equal Protection Clause. And so at the time, there were, for various properties, especially residential ones, racially restrictive covenants, which you can still see in deeds and title documents today if you look back in the title history for certain properties. And in 1948 in Chicago, this was made especially clear by the Supreme Court that these types of racially restrictive covenants were illegal and that the government could not bar someone from owning land based on their race. And we still see the effects of these zoning policies today. Fairfield, as I guess, more recent, most of the subdivisions here are relatively newer compared to some of the other areas of the Bay Area. But in places in the East Bay, San Francisco, Vallejo, parts of Marin County, you can go back in title documents and see racially restrictive covenants in those deeds still today. They're not enforceable anymore, but they still exist, and the legacy of those policies still affects our society in really profound ways. And so here as zoning or planning commissioners, you have a really important role in making sure that the use of property is regulated in an ethical and in a moral way. The book that is there, the cover on the presentation, The Color of Law by Richard Rothstein, is a really great read and kind of explains how those policies came to be and how they were struck down, but still how some of the impacts impact our society long after Shelley versus Kramer. Various banks in terms of the types of loan products they would offer to people, and insurance companies in terms of the type of homeowners insurance that you were able to receive in certain areas of towns, maintained those policies long after it was illegal for the government to do so. And so, now still 60, 70 years later, we still see the effects of segregation on our local communities, and we just wanted to impress upon you, the importance of this role and why zoning policy is so important and how you can shape its history going forward. So, like I mentioned earlier, the police power is kind of the area of the law that is left up to local governments to regulate and pass legislation on, but it's not absolute or unlimited. The state and federal governments also preempt certain types of regulations and policies from going into effect, and that affects many aspects of local land use and zoning. And so basically the structure is that local law can't conflict with state law, and state law can't conflict with federal law. Obviously, local law can't conflict with federal law either. And basically, a statute or an ordinance at the local level is said to be preempted by state or federal law if it duplicates, contradicts, or enters into an area fully occupied by general law. So we're not able to pass certain types of ordinances at the local level because the state or federal government has already told us that those areas are preempted. Some important examples in the zoning context are telecommunications. The FCC has significant regulatory oversight over how telecom technology and infrastructure is put in through cities. I think probably the most recent example of that is kind of 5G infrastructure and how it's made its way through local governments and how the local governments are kind of not able to prevent those technologies from coming into their communities, which in some places has created a lot of conflict. Also, the big one, I think, for all California communities is housing policy, right? The state is becoming increasingly aggressive about how it tells local governments how many units they need to build and what types of units they need to build. And also in the area of CEQA, which we'll get to later, right? SB 330 limited the number of local meetings or hearings you can have on a project before it has to ultimately be approved or denied. SB 9 is this very recent law that allows any single-family house or single-family resident zone to be turned into a duplex, so there is no more single-family housing zones in California. And then also with appropriate setbacks and lot sizes, any lot in California can be split into two lots, which many people suggest would allow any single-family home to become ultimately 4 residential units if they're able to split the lot and build 2 duplexes on each of the split lots at that point. Another area is family daycare and community care facilities. The state has legislated that these types of facilities need to be allowed in residential zones, and that's not a assembly or care use in certain circumstances. It needs to be permissible at the local level in a residential zone. So just generally, the general plan in a city is kind of the long-term policy document that talks about what the vision for the city is for the future, and there's a number of required elements in a general plan, including land use, circulation, which refers to traffic and public transportation. Housing is obviously a big one, and the one that needs to be updated most frequently for cities. And so these types of policy goals come for your commission for recommendation, and you advise the city council on what should be approved in the general plan. And then the zoning code is kind of the more specific version. It applies parcel by parcel rather than generally over the whole city. Any zoning code amendment has to be consistent with the existing general plan at the time, and it's rather than reflecting future conditions, the zoning code more reflects current conditions. So now we're going to get into the different types of hearings that come before your planning commission. Generally, there's two main types of hearings, legislative and quasi-judicial hearings. Legislative hearings refer more to policy-oriented actions, so you're changing the ordinances that exist in the city, you're amending the general plan, you're amending specific plans or creating new specific plans, development agreements with developers for large, certain types of large developments, and contracts for the city, improvements on publicly owned property. These types of things all fall within the realm of legislative enactments, and in that role, you're serving as a legislator, right? You're advising policy and how the city council should go about making those determinations. In quasi-judicial hearings, that's when an individual property owner or developer comes before the board, they submit an application for a project approval, and then you're making an individualized determination, not a policy objective that would apply broadly across the city, but rather something that applies to that specific applicant. So as you can see, there's a number of examples listed here. Probably the most common one is a design review application, or conditional use permits. Variances may come before your board or commission from time to time. And so again, those are more individualized decisions for a specific property. So just a couple of somewhat recent examples. A legislative example is the Heart of Fairfield specific plan, right? And as that plan comes before your board or commission, you'll be advising the city, recommending how they should shape that policy for the betterment of that area of the city. A quasi-judicial example recently is the Hyatt Hotel along I-80 at North Texas, where you approved a conditional use permit for a hotel and drive-through. And so you can kind of see the difference there. One policy that applies a little more broadly and has an impact on a number of parcels, as opposed to a more specific project approval. So again, there can be situations where you're kind of sitting with both hats, right? You have both a legislative decision before the commission and also a quasi-judicial decision. And when those things come about, you have to be aware that you're acting in an advisory role, in a recommendation role to the city council on the legislative portion, and you're acting, as an arbiter, as a decision maker on the quasi-judicial portion. So a good example of that is, maybe a larger development that requires a general plan amendment, which would be the legislative portion of the decision, but then also requires design review and a conditional use permit approval, where you're making a more specific, individualized change. So a little more on legislative hearings. So like I mentioned, a legislative hearing is where you're framing a rule or a policy for future application. It has broad application. It doesn't apply to a specific property, but rather you're making a change that would change the city's policy. And again, examples of that are general plan text or land use map amendments, zoning code changes, these sorts of policy decisions. And in that role, the commission acts as a recommending or an advisory body to the city council. You don't make the ultimate decision, you are making recommendations for what the city council should do. And in that role, you have wider discretion. And so you're not required to make findings, but they can sometimes be statutorily required or just useful in certain circumstances. It's more permissible to talk to others outside the hearing, right? You're not acting as a neutral decision maker, right? You're trying to shape policy for the future, what you think is best for the city. And there's no procedural due process, which we'll talk about a little bit more when we get into the quasi-judicial aspect. But basically what that means is you need to be a fair, impartial decision maker, not bring biases or policy objectives into the decision. You're applying, you're making, in a legislative hearing, you're making policy as opposed to applying policy. in a quasi-judicial hearing, that's one where you're, again, applying the law to a specific application, to a specific project proposal. You review the proposal and you determine whether it meets the law as it exists currently. There's not an opportunity to change the policy, rather you're simply applying law to facts. So examples of that, like I mentioned before, conditional use permits, variances, design review, that's where you're applying law to the facts. And your discretion there is more limited, right? You can't change the policy, you can just apply the policy to the facts at hand. And like I mentioned, for quasi-judicial hearings, you have procedural due process concerns. And so you need to be a neutral decision maker, fair and impartial. Your job is to weigh the evidence, and you must make findings in a quasi-judicial hearing. And we'll talk a little bit more in a minute about how findings are so important in those hearings in order to make sure that your decision isn't challenged or ultimately overruled by a court. And by all means, feel free to interrupt me if you have any questions, or I should have mentioned that at the beginning. I hope to keep this under an hour, but if you guys, feel free to interrupt me and give me a break. So again, an example of a quasi-judicial hearing, and kind of maybe the quintessential example, is deciding a variance decision. So variances are a specific construction under state law, and they require that the property has unique circumstances that mean that if you applied the existing law as it is, that person would be disadvantaged, or they would suffer some hardship compared to other similar properties that have the same types of laws that apply to them. And so this is the code section in the Fairfield Municipal Code that discusses the findings required for a variance. And so when you're shaping findings around a variance, these are the exact words that you need to put in your decision. And finally, if you have any confusion about the role of the commission, those roles are defined in the Fairfield Municipal Code, section 2.25, and also the enabling ordinance, which I believe was enacted way back in 1946, and which established the Fairfield Planning Commission, and so kind of laying out the differences between your legislative capacity and your quasi-judicial capacity. Okay, so a little bit more on findings and conditions of approval. So findings are basically, in the law, they explain to the court how you got to the decision you got to based on the evidence that you reviewed in making that decision. And so this Topanga Association for a Scenic Community case is the primary case on this topic, and it describes findings as the legal footprints that the agency must leave in order to bridge the analytic gap between raw data considered by the agency and the ultimate decision made by the agency. They expose your analysis, your facts, regulations, and policies. And so this case was a variance application from a property owner down near Malibu in the Topanga Canyon. And basically a bunch of angry property owners didn't like that this person was applying for a mobile home park permit in their single-family residential 1 acre minimum lot size, and there was some agricultural uses available on those properties also, so that was kind of the nature of the zoning code. Obviously this applicant wanted to do something very different with it, and the problem that the court found with the findings that the agency made at the time was that they really only considered the property in question, and they didn't compare it to the other similar properties around it, right? And so they said that they were going to move the highway so that they could facilitate this use, and they would create a sound wall and a aesthetic barrier so that people wouldn't have to look at the mobile home park, but they didn't really describe how that property owner was disadvantaged or had a hardship like we just described compared to other similar properties in the area. And so ultimately this person did not get to build their mobile home park, and the NIMBYs in the area won. And so that is kind of a quintessential case for why it's important for agencies to make the correct findings and understand how to craft findings and not just discuss the individual property that they're approving a project on, but rather instead they get to have instead they must compare it to other like properties in the variance context, show that hardship, show the difference between the two parcels. And so, again, like I mentioned, for quasi-judicial actions, findings are always required. You have to make that explanation. You have to bridge the analytic gap for the court, showing why the evidence led you to your decision. Sometimes they're also required by statute or by local ordinance for legislative actions, but it's particularly in that quasi-judicial decision-making context that you need to always be aware of the findings you're making. Again, the purpose of findings is to apply the facts to the law, show the reviewing court why you're making the right decision, and also more at the local level, right, in a case where you don't expect to be challenged, but also show the public why, the project meets the criteria set up by the city to be approved. That PR function, right, you're showing that you acted thoughtfully and reasonably given the facts you were given and the law as it exists currently. So in making findings, it's important to show your work. Again, you're bridging that analytic gap for the court and for the public, so you're connecting evidence and facts. Can't say that enough. The special phrase under the case law is substantial evidence, and so you need to show that you have that substantial evidence in the record that you reviewed in order to prove to a court that you made the right decision. Using the word because is very helpful when crafting a finding. Often people will just kind of regurgitate or repeat the legal standard as it exists, but not explain why the facts met that legal standard. And also, again, tie your findings back to established policy, plans, standards, all the different legal aspects of your decision, and why the evidence and the facts before you meet those standards. So now moving on to conditions of approval. Conditions of approval are going to be required in any discretionary project, right? So one, as opposed to a ministerial project, a discretionary project is one where you actually have some, ability to judge the qualitative, measures rather than just a strict checklist or objective standards that exist under the law. That's what we call a ministerial approval. So conditions of approval are always going to be required in a discretionary action. Examples are, a conditional use permit will always have conditions of approval. Conditions of approval run with the land, and they're not tied to an individual person. So to the extent a developer sells their project halfway through completing it or sells a portion of the land, those conditions are still going to apply to that parcel regardless of who owns it. It's not tied to the applicant. And then they must be reasonable. And so there's two main constitutional constraints that we talk about in that reasonability analysis. We'll get into that in just a second. The first one's called the essential nexus. That's making sure that the condition that you're applying has a connection to the project, the impacts of the project, and then rough proportionality, which is that your condition can't be overzealous. You can't ask too much of an applicant or a developer when approving a project. It has to meet both the connection to the project, but also the impact of the project has to be proportional to the impact of your condition. So another couple fun cases on these constitutional standards. The first is Nolan versus the California Coastal Commission. In this case, you see the picture on the right. There's a little beach bungalow that existed at the time, and then on the picture on the left, that's the house that exists today. And as you can see, the area has been developed really heavily right along the beach in Ventura County. Basically, this family, the Nolans, they owned this little beach bungalow and wanted to get a coastal development permit from the California Coastal Commission to redevelop the house and make it bigger. And as part of that permit approval, the Coastal Commission asked for them to give an easement along the beach in front of their home in order to get that permit condition. As you can kind of see there in the new recent picture, there's a county park off to the left and another beach access that was called the Cove off to the right, and the Coastal Commission's objective was to connect those two beach access points with an easement along the waterfront. And so what this case went all the way to the U.S. Supreme Court, and they said that there was no direct nexus between the condition of an easement along the waterfront and the permit approval of building a new house on the same parcel. It had a larger square footage, obviously, but the court held that that was an unconstitutional taking because it didn't connect. There was no beach access before. There was no reason why rebuilding the home necessitated having this easement. The impact of the home did not result in preventing anyone from accessing the beach in a different way than what was there before. And so the Coastal Commission's condition of approval was overruled. Basically, it was an unconstitutional taking, which meant that the government didn't pay fair market value for taking that portion of the property. And what the court's reasoning was basically if the Nolans hadn't come forward for a permit approval, right, and that the Coastal Commission told them, hey, you need to give us this easement, that'd pretty obviously be a taking, right? You can't have somebody coming in and taking a portion of your property when they're not paying for it. And so because there was no nexus, the Supreme Court didn't see a distinction there. They said it's still a taking. The only difference here is that the Nolans asked you to come forward with this permit. And so the second standard is rough proportionality. And this case was up in Oregon, also went to the U.S. Supreme Court. And here, a woman named Florence Dolan, she owned a plumbing and electrical supply store, and she came to the city with a permit request to double the square footage of the store and also to pave her parking lot, which was a dirt parking lot at the time. And so the city, as their condition of approval of that permit, they wanted her to give a swath of the property along this creek as a greenway, which they connected to flood mitigation. They said that if you're going to be paving this surface and making it more impervious, the flood risks are going to increase, and so we need you to dedicate this 10% portion of your property to the public and allow a public easement through it. And they also required her to build a bike path along that greenway because they said the increased square footage of the store would create more trips and make more people have increased traffic for the area. And so in an effort to mitigate the traffic, we want you to build a bike path so people can get to your store in a different way. And so there the court said, well, it's not the same situation as Nolan, where there's no essential nexus, right? The city has done its groundwork in order to show why the condition is at least connected to the condition that we're asking for. But the problem is that it's out of proportion with what this person's asking to do. And so they said it's an unconstitutional taking to ask this woman to give up 10% of her property for this when her ultimate project isn't creating that significant of impacts on flood risk or on traffic for the city. And so again, overruled as an unconstitutional taking by the city. And so these two standards kind of have guided a lot of conditions and dedications and all these types of exactions taken by cities and any kind of local government going forward. And they kind of have the nice rhyming names, Nolan and Dolan, that makes it kind of the law school quintessential cases to learn about takings. And so I guess a kind of quick shorthand to think about nexus and proportionality. Nexus requires that sufficient connection, right? That's more the qualitative element of the analysis. You need to show that the idea behind the impact is connected to the idea behind the dedication or the condition being asked. And then proportionality is more the qualitative aspect, right? It needs to have at least some rough proportion, some rough proportion to the level of impact for the project. And so this structure also kind of guides now what most cities do in many circumstances is require mitigation fees rather than actual dedications of land or exactions or building certain facilities or public projects from the developer, but rather we just request fees. And that's all part of the Mitigation Fee Act, which is codified in California law and really relies on Nolan and Dolan in terms of creating that same structure, right? In a request for fees from a developer or a project applicant, you need to show that you need to tell what the fee is going to, and you need to show that it is in a rough proportion to the level of impact for the project. Go ahead.
Okay, can we stay on this slide? I'm gonna try to find the words for this, so bear with me. If we can talk about what constitutes condition, right? So I say that to ask about, and I've already kind of had a conversation about this, but I'm bringing it up for discussion because this comes up a lot because of the area we're in. A lot of Solano County deals with crime. A lot of it has to do with the surrounding communities. Maybe someone's next to a park that's been struggling, or, just a neighborhood in general, or, and so when we're talking about the condition that determines, what the burden of the project should be, are we at liberty to look at the surrounding conditions to determine what the burden of a project should be? So for instance, do we look at the fact that there may be some unsavory conditions going around, so then maybe going on around the area, so then maybe we're looking at asking the developer to put more lights around their property or more safety measures? So I'm just wondering about the conditions, because if it's already zoned to be in that particular area, us as a commission, we don't have much authority to say anything outside of it, because according to the other slides, as long as it's within, the zoning, the purpose, if that's the word we want to use here, as long as it's within the guidelines of the zoning, then we're just looking at how well the property or the project fits the zoning permit, if that makes sense.
Yeah. And so, you have kind of touched on a crucial conflict, I think, in a lot of development applications, right? And cities are often have a lot more discretion or latitude to ask for conditions when they get into some sort of development agreement situation, or they're able to, show that a project has a specific impact on the surrounding area, right? But what you're not allowed to do is say, this area is already like this, you're not making it any worse, but we're going to require additional exactions out of you because of the situation as it stands, right? And so this is it's a difficult situation, right? And so I guess in larger developments, right, maybe not an individual project application, but a large subdivision or something like that, cities can, condition additional public safety buildings, police departments, fire departments, more parks, more trees, they're more at liberty to have latitude. But you're right that when the zoning code is, permits that use or purpose, as you put it, right, and the project meets all the criteria of that area, generally it's not allowed to condition that property to fix the surrounding area just because, they happen to apply in that area. Does that make sense?
Yeah, that makes perfect sense. And I mean, I'm concerned about it because of the perception of the public. The public will often come here and think that because, we sit where we sit, that is one of the conditions that should be met, because that's an automatic burden of the project. So then in that case, it looks like the public should be directed more or less to, address the city council, because that would be then on the city council. Is that correct?
To the extent that they could change zoning policy or require certain types of conditions, yes, it could be directed to the city council. But the city council is also tied by Nolan and Dolan, nexus and proportionality, right? They can't approve conditions of approval that would ultimately get thrown out, or if the applicant decided to challenge those conditions in court, right, they might have a winning argument if the project doesn't have impacts that actually result in the condition becoming worse, right? And so when you're making these conditions, again, it's bridging that analytic gap, finding the impact and showing how your condition addresses that impact. And so certain types of developments, right, we might say that it increases crime, or, there's types, often with like liquor stores or certain, cannabis dispensaries, certain types of uses that there is a tie to some sort of crime impact, then there might be more latitude in order to ask more of the project applicant. But a single-family residential home next to a park that's had some difficulty in the past, it's going to be hard to ask that project applicant to do a lot to fix the park, right? It's not proportional to the amount of change that they're creating in the neighborhood. Does that make sense?
Yeah, and if I can just add a few things. So, there could be some off-site conditions. There might not be enough street lighting off-site. There might be sidewalks that aren't complete. There might not be enough parking on the neighborhood streets, things that are off-site to that project. They might be in the public right-of-way. Particularly if they're in the public right-of-way, that's where the city council can make decisions, direct staff to work to make certain improvements in the public right-of-way, things like that. That's where the city has a lot of latitude to work within our own right-of-way, not on private property necessarily. So there could be off-site conditions where, that's where, the folks should probably talk with the city council to get some direction back to improve conditions elsewhere that are within the city's control, or if it's policing, things like that. But it's difficult to put requirements on a developer to pay for 3 new police officers in that particular neighborhood. That's more city council making decisions about how we allocate city resources. So the other thing I'll say is that as you're reviewing projects, a couple of things we talked about, findings. As you review the resolution that comes with your staff report, you act on a resolution. You decide to approve or not approve a resolution. The language in that resolution, if you read it, actually has the findings coming out of our zoning code that you're required to make to approve a use permit or a quasi-judicial entitlement, like approving the hotel, things like that. The findings are actually listed in there, and there's a discussion that staff has put in that for you to consider that explains why we think the conditions of approval or the facts of the project satisfy the findings, that you're able to make the findings that you need to make. So you as a commission don't have to draft those, but you should be reviewing your staff report and particularly the resolution, and read those findings and make sure that you concur with them. Or if you have concerns about some aspect of the project, there could be changes that the commission could add conditions of approval that fall within the nexus and proportionality. Or if there's areas where we have adopted standards that you think there's additional conditions, you are welcome to discuss those at the dais. You can also engage with staff and the city attorney to weigh, is this something that we could propose? We like the project, we want to approve it, but we think there's another condition. Is this something that we can add? If you're not sure, we're here to guide you in that discussion. But ultimately, the findings that are in your resolution are essentially the decision that you're making. You're making those findings.
Right, and when you diverge from what the staff recommendation is, right, that's when you'll hear Dave or I pipe up and say, okay, well then we need to modify our findings here, because the findings that are in the staff report as exist don't reflect the decision that the commission's coming to, right? And so that's when we're going to have to be able to kind of think about nexus and proportionality on the fly, and come up with some different ideas around drafting findings or conditions of approval.
Yeah, and touching on one of the other items that Ethan mentioned earlier, if we have existing adopted zoning standards, parking standards, things like that, that's regulations that are in place. The commission typically doesn't have the authority to make a finding that the project doesn't comply with the zoning, that there's not enough parking. If the parking standard is set and says, here's how much you have to provide, and they're providing it, you're essentially obligated to make a finding that it's consistent with the zoning in that regard. If you're concerned that our zoning standards don't require enough parking, that's then where you go back to that legislative role that you have, and you discuss agendizing a discussion of whether or not you want to make a recommendation to the city council to change the regulations for future projects. So, go ahead.
So yeah, again, just getting back to drafting a condition of approval, to the extent we wanted to change any conditions. You know, generally, staff is going to be the ones drafting conditions of approval, but to the extent you want to modify them, it's important. This won't stay in place. It's important that we kind of meet these elements, right? And so we need to describe who is implementing the condition, whether it's developer or some other party, what the condition is, what's being required. A lot of the nexus and proportionality will kind of go into the what discussion, when the condition will be implemented, and why the condition is needed. And again, that's where nexus and proportionality comes in. You can show the court, why you've applied facts to law and how how the project's impacts are going to be mitigated by the condition that you're proposing. Okay, so now a somewhat brief discussion on CEQA. So CEQA stands for the California Environmental Quality Act. It's codified in the Public Resources Code, but probably more relevant, I think, for both lawyers and planning commissioners are the CEQA guidelines, which are regulatory. They're produced by the state, and they have a whole set of regulations that kind of guide how CEQA is to be implemented, and they're actually written in fairly plain English. I would say that they're far more decipherable for most people than the actual Public Resources Code, and they can be a really useful guide just to kind of explain how CEQA works, how it's actually implemented practically, as opposed to maybe some of the more lofty goals and policy-oriented language that's in the statutes. Oh, and just there on this screen, there's a link to the guidelines online. They're available for free, and it's definitely helpful to kind of have an understanding of what's in there. There's a lot of helpful things, and we'll get to it in a bit, checklists and flow charts and types of things that just describe the different processes and steps that are in the approval process for CEQA, just all kinds of helpful guidelines describing what's exempt, how to apply CEQA in different circumstances. So CEQA has two main goals. The first goal is transparency. It informs both the decision makers and the public about the approvals and what decisions are being made, what environmental impacts exist, and how the government's going to go about avoiding those impacts or mitigating them. And just disclosing to the public when a project will have a significant impact on the environment. CEQA is not a bar to any environmental impact. It just requires that those impacts be analyzed and they need to be disclosed to the public and to the decision makers. And then the second goal is the mitigation of impacts. So we identify what environmental impacts there are from a project and what we can do to avoid them or potentially mitigate them. The CEQA is not designed to provide a specific outcome on a project, right? It's not necessarily a statute designed to say no to approval of projects. So you can approve a project even if it will have significant adverse impacts on the environment, whether or not those impacts are fully or partially mitigated. As long as the EIR, which is the Environmental Impact Report, is prepared and the disclosures are made, and the approving body prepares what's called a statement of overriding considerations, which basically explains why developing in this way is worth having that environmental impact, then you've met the requirements under CEQA and you can still approve a project. So we're going to go through now just the basic steps of how a project gets approved and evaluated under CEQA. So kind of what we call the step zero is whether or not a project even exists. And sometimes that can be a tricky question. Basically, a project under CEQA, as it's defined in the statute, is a discretionary activity, so ministerial projects are not projects for CEQA purposes. And that the question is whether they may have a significant impact on the environment. So at this initial step, you're not studying the project, you don't have a real sophisticated understanding of what impacts exist. You're just acknowledging that this project is likely to have a impact on the environment. And again, a project can be not only a development approval or something physical, right? Policy changes can also be CEQA projects. So changing the zoning code in certain ways. A general plan is almost always going to have a pretty significant CEQA analysis. And so it's not just an approval of a development, it also includes legislation. So again, CEQA can apply in both the legislative hearing and also the quasi-judicial hearing. And you also need to consider, the whole of the action. There's a prohibition in CEQA case law against piecemealing, which is trying to break your decision apart into little pieces so it doesn't look like it has a significant impact on the environment when the cumulative action would have a significant impact on the environment. So then we get to step one, and that's kind of where we determine whether or not a project is exempt. And so, again, the first step is whether there's a project, and then the second step is whether a project is exempt. And there's a number of statutory exemptions for CEQA. That includes, things like the Olympics or restriping bike paths, any sort of emergency project that's taken, under an emergency declaration or needs to happen immediately. Ministerial projects, as I mentioned, have a specific statutory exemption, and obviously any project that's denied is not a project for CEQA purposes. And so that's kind of the first analysis, is you decide whether or not any statutory exemption applies. Secondly, there's a whole list in the guidelines of what we call categorical exemptions, and they get termed with classes. And so people will talk about class 1, class 4, class 5 CEQA exemption. And those apply to things like infill development, so redeveloping on top of property that's already been developed, making changes to existing facilities, or minor alterations to land or minor alterations to existing structures. There's, in the guidelines, all these different exemptions that might get you out of having to do a full CEQA analysis. Then that next little part of the outline there talks about the exceptions to the exemption, which is a really fun legislative creation. And deciding to use a word that's so close, but basically exceptions to the exemptions will apply. The main one is that unusual circumstances are present that means that despite this project being exempt, we should still probably study the environmental impacts of it. Lastly, there's the common sense exemption, which is pretty nebulous, but just refers to this idea that it's not the change that's being made, whether that's to policy. Generally, a policy change is the one that will fall under the common sense exemption. There's no potential for any environmental impact. This is not the type of action that has impacts on the environment. So just by a common sense rationale, we're going to say that the project's exempt from CEQA. So then our next step is to do the initial study. And the initial study determines what level of environmental review is needed. And basically what we're doing there is identifying which different types of impacts are going to require significant study or evaluation for the level of significance. And so the CEQA Guidelines Appendix G has this checklist, which here's a little snippet of. And basically, as you can see, this checklist shows air quality and biological resources as the different topics that are being studied, and it kind of shows, you check one of these boxes, whether or not it's going to have a potentially significant impact, so definitely needs to be studied under CEQA. A less than significant impact with mitigation, so we're able to mitigate it to a less than significant level such that we don't need to do a full-blown environmental impact report, but instead might be able to do what's called a mitigated negative declaration, and we're going to get to those types of environmental documents in just a second. And And then a less than significant impact, so that project would not need to be evaluated under CEQA, or no impact, right, the kind of common sense exemption. There's no chance for this type of project to have an impact on specifically air quality or biological resources or cultural resources, traffic. There's all types of different types of environmental impacts that are included in the guidelines. And so just depending on the nature of the project, these different check boxes kind of show what the study is ultimately going to encompass. So these are the main types of environmental documents that are ultimately produced from CEQA, and generally staff or consultants are going to be hired to produce these documents. A negative declaration is just a statement that the project is not going to have a significant impact. A mitigative negative declaration, which I just described, that means we've identified a potentially significant impact, but we think if we implement this condition or this mitigation measure, we can mitigate that impact such that it's no longer a significant impact. Or the environmental impact report, which is kind of the full-blown, we need to study this fully and acknowledge that there's a potentially significant impact on the environment here. And so most projects you'll see that come before your commission are probably going to generally fall under some sort of exemption. I'd say the majority of projects. Then kind of the next biggest class is probably the MND, the mitigated negative declaration. Those projects are generally ones where we're able to approve it because we're able to get those significant impacts down to less than significant levels. And then EIR is probably the least frequent that you'll see come before the commission, but you might see one every couple of years. Generally, a general plan or specific plans are going to have a full EIR, and we'll get to kind of the reason why in just a minute. But there's different types of EIRs that can be produced. The program or programmatic EIR refers to generally some sort of policy change that is going to have a really broad impact. So we're going to do a really big EIR to study a lot of different types of impacts. And then smaller projects can then refer to that programmatic EIR in order to have to do less subsequent environmental review. A project EIR or a focused EIR, a smaller level of environmental review. We're going to probably evaluate a fewer number of impacts and be able to approve the project based on that level of evaluation. So in kind of trying to decide what level of impact or what level of environmental document needs to be produced, the basic question is whether there's a significant adverse impact on the environment. If there is, then you generally need an EIR. If you can mitigate it, you need an MND. If there's no significant adverse impact on the environment, then you can do a negative declaration. And so these are just, really more for your reference later. Like I mentioned, the checklist evaluates all these different types of potential environmental impacts. And as you can see, it's pretty wide-ranging and includes a lot of things that most people might not consider, strictly environmental. So keep in mind that, California has really expanded the Environmental Quality Act to include all types of different things. Cultural resources, for example, as historic preservation or native and tribal resources that might exist on the project. Transportation will include everything from public transportation, but also traffic, parking, that sort of thing. Noise and light and all kinds of different things are evaluated under CEQA.
Question?
Yeah.
Sorry if no one else has questions.
Oh, it's great.
Y'all know I'm full of questions every meeting. So can you please tell me what's considered as under CEQA when you talk about aesthetics? Because I believe that this has come up with a number of projects regarding like aesthetics and how it works. Like say if you have a more rural area and maybe like a larger project comes in that's like outside of the typical like height. So what constitutes aesthetics in CEQA?
Yeah, it varies a lot depending on the jurisdiction. View sheds are often considered, rural character, like you mentioned. In urban areas, there's a lot of different types of how a building looks just in design review type considerations. And so, I think Dave had something to add, but I don't know if you have more specific ideas about what is important in Fairfield.
Sure, absolutely. So, and I'll before I answer that question, I'll just give you a little context. Ethan's talked about the checklist and the different types of CEQA review. So maybe half of the projects that come before you, staff reviews it against the California Environmental Quality Act and concludes that we believe it's exempt from the law and that you don't have to do a detailed analysis. As a part of the findings that you have to make for a project, you have to make findings that the project complies with the California Environmental Quality Act. So in your resolution, there will be a statement that staff drafts that, we believe that you can make the finding that it complies. Roughly half of them it complies because we've concluded for you that we believe it's exempt. The commission has to review that and concur with that. That's about half the projects. The bulk of the rest, we actually do have to, we find that it's not exempt, and you have to go through a checklist. And you prepare the initial study, and so with your staff report will be the initial study that uses the checklist that includes these categories here, including aesthetics, and I'll talk about aesthetics in a moment. But for the 5 of you who have been on the commission over the last year, you'll recall that we had what we called a scoping meeting for the environmental impact report for the apartment project, where we were hearing from the commission and from the public, what are the issues you're concerned about? And coming out of that meeting, the commission asked me to send you a copy of the checklist. And so if you look back in your emails from me, you'll have an actual copy of the CEQA checklist with the list of all the questions. So under aesthetics, there are maybe 3 questions that we have to answer. One of them has to do with glare, if I remember correctly. And so we're looking to see, is the project going to create glare that creates very bright reflections off of windows or things like that that affect the neighborhood? Or are there light sources that the project's going to produce, unshielded lights that are shining in other properties' windows, those kinds of things. The other area that it talks about, and this more gets to city policy, it asks, and I don't want to quote it directly, but whether or not it's impacting any scenic vistas. And so the city actually has adopted a document called the Scenic Vistas and Roadways Plan, or if it affects scenic roadways. So we've adopted a policy document, the city council adopted maybe 20 years ago, a policy document that staff uses to review against that question that looks to see, is the project along a scenic roadway? If it is, there's conditions that are recommended in our Scenic Vistas and Roadways Plan about how you mitigate scenic impacts along that roadway. Or is it in a scenic vista area? And the city's adopted certain scenic vista areas. And so staff, as a part of the analysis with this checklist, we will review it against that policy document to determine, is it along a scenic roadway? Is it in a scenic vista area? Are there glare? Are there light sources that are causing issues? And so in that initial study, if we determine that it's not exempt, then we'll provide that analysis for you with your staff report. And so you can read that and see both what the questions are as well as staff's recommendations to you about how we deal with those issues.
And then the city document is just for the scenic roadways, or is also for the scenic vistas as well?
The city has designated certain scenic vista areas, view sheds that were deemed important to the city, and that we want to make sure that new development doesn't significantly impact the quality of the view into that area. And I can, for the commissioners, probably when you started on the commission, I sent you links to these. Our 2 new commissioners just sent today, I sent you, just before this meeting, I sent you links to some of these documents. I'll resend that to the commission as well, just so that you've got a fresh copy of that document as well as a few other documents, including the checklist. I sent that to the commission a few months ago. I'll send that to the new commissioners.
All right. only a few more slides. Go ahead. Oh, no question? Okay. So again, it's important to analyze all the impacts of the project, right? We don't want a piecemeal, and part of that analysis can be what we call cumulative impact analysis. And so we need to look at the different types of impacts that could be caused by this project in addition to other projects that are going on at the same time, and also indirect impacts that the project might have. And so sometimes, the individual project's impact is going to be less than significant, but if we consider it with other types of impacts from other projects, or also, just multiple different types of impacts within the same project, we'll determine that the project now does have a significant impact on the environment, so we need to enhance the level of environmental review that's going on. But generally, we don't need to consider economic or social impacts of a project, right? So, like I said, CEQA evaluates all kinds of things, but one thing it's been ruled by the courts to not consider is, the type of economic or social concerns that physical impacts that might result from those things. So, urban decay or blight is kind of the main one. This Bakersfield case had to do with a Walmart project, and the community was concerned that it would depreciate, property values or that sort of thing, and these are not CEQA environmental impacts. Not to say that they're not project impacts, they're just ones that aren't going to be evaluated in an environmental review. And then the phenomenon of reverse CEQA, which is kind of the idea that CEQA studies the project's impacts on the environment. It does not study the environment's impacts on the project. And so often traffic is the one that gets mentioned here a lot. Just because there's an existing congestion issue in the area, you're studying how the project will increase that congestion, but you're not necessarily studying or trying to mitigate the currently existing condition, right? And so a project can be asked to mitigate its own impacts, but it doesn't have to mitigate the impacts of an already pre-existing condition. And a little more on traffic impacts. Just recently, in 2020, it's been the official shift from what we call level of service analysis to vehicle miles traveled analysis. And so this Senate Bill 743, which passed in 2013, it was kind of a gradual shift, but now all local agencies as of July 2020 are bound to for any land use approval project, they're bound to study the traffic impacts with vehicle miles traveled rather than level of service. And so the distinction there basically was that level of service measured the capacity of roads to accommodate the increased traffic from any specific project. You need to study the delays and potential for roads to be improved upon to mitigate the impacts. Vehicle miles traveled studies just the number of trips that the project adds to current conditions. And so the reason the legislature made this change was that level of service allowed local agencies to mitigate impacts by widening roads, making more roads, building more roads, and ultimately what the state legislature has decided is important for CEQA concerns is the amount of greenhouse gas emissions that are going to be produced by a project. And so ultimately, they made the decision to change the way we evaluate these impacts. But this change has frustrated a lot of local governments across the state. Basically, the legislature came out and said they don't really care about congestion, or they knew that this change was going to result in increased traffic, but ultimately they think that the greenhouse gas emissions are the more important factor for environmental analysis. And this law, also the VMT in the guidelines, they describe specific exceptions for certain types of projects, particularly transit-oriented projects, which are these projects that are within a half mile or a mile of major transit stops or corridors. And so the the idea from the legislature was that they would try to push more development into those high-quality transit corridors by making them exempt from the VMT analysis. That being said, COVID has happened and no one's taking public transportation, so I guess we'll see how this change plays out. Ultimately, most local governments are viewing this as increasing congestion concerns, but potentially decreasing the amount of total greenhouse gas emissions. So, like we mentioned, if we do identify a potentially significant impact, then the next step is to try to figure out how we can mitigate that impact to make it less than significant, such that we could then do an MND rather than an EIR. And so basically the requirements for mitigation impacts is that they must be enforceable. So you have to do monitoring and produce a reporting plan so that there's a plan going forward for how we're going to make sure that the mitigations that we've identified in our MND are actually going to be followed through upon. And like conditions of approval, mitigation measures need to have nexus and proportionality, right? We need to identify what the impact is, show how the mitigation measure addresses that specific impact, and also that it's in proportion to the amount of impact that the project causes. So again, when designing mitigation measures, there's kind of this constitutional framework to work under. And then, kind of consistent with the idea that these need to be followed through upon, you can't defer mitigation to a future date unless, there's a situation where the MND provides a menu of options for a specific project, and that just kind of really depends on the nature of the project and how future studies might be able to mitigate that same impact. Again, this kind of often comes into the context of cumulative impacts or situations where there's multiple projects being approved and you're studying the impacts of all of them individually, but also having that cumulative impact analysis and how we can mitigate a cumulative impact through a number of projects. This is just an example of a mitigation measure. This was for that hotel approval on North Texas for the Hyatt Hotel. Basically, the mitigation is related to removal of trees and vegetation, and it requires them to do it outside of the bird nesting period, but to the extent it's not possible to do it outside of that period, you have to hire a biologist who's going to conduct a survey. And so this is all part of the mitigation plan that has to be produced that I referenced earlier. And so it kind of shows how, again, we're connecting the mitigation measure to the impact, and then also the proportion of the impact to the level of effort we require of the person trying to implement the project. And so when a project ultimately comes before your body for approval or your recommendation to the City Council for approval, all of the CEQA analysis needs to be complete. We need to certify that environmental document. We can't go ahead and move forward with project approval before that environmental document is been produced, so that, again, it's this disclosure of impacts and public notification process. And so whenever an environmental document is produced, that's a public document, and the public gets a chance to review the impacts of the project, just like the decision makers. And again, EIRs require findings of fact. So again, we have to make findings that show how they bridge the analytic gap, right? That show how the evidence leads to the ultimate decision that the approving body is making. And I got into this a little bit earlier. So there's this process whereby environmental documents can tier off of one another. So like we said, there's the large programmatic EIR that can do a really comprehensive analysis that will then allow subsequent projects that fall within that that program to use that analysis. And so the example given here is, a specific plan EIR will analyze all the impacts for a planned development, and then when an individual, say a single family house, comes up for approval within that specific plan, we can really rely on the specific plan or tier off of the specific plan for a lot of the analysis and just focus on the unique site-specific impacts that weren't specifically analyzed in the broader document.
And that comes up a lot if we're bringing you a project that's within our train station specific plan area or the heart of Fairfield. Each of those have environmental impact reports that looked at the big picture set of environmental impacts, proposed mitigations, and we will typically substantially reduce the amount of extra analysis that we have to prepare for the commission when we bring you a project, because the bulk of the analysis has already been completed with that EIR, and we're only looking at a much narrower set of issues that are specific to the actual development project in front of you.
All right, and last slide. Basically, just to recap, the purpose of CEQA is not to stop projects, it's not to generate paper, it's not to create more work for you all and for staff. It's really just to make sure that everyone's informed at all levels of government and also the public to the environmental impacts and consequences that could come up in a project. And again, we want to make those decisions with informed and balanced and reasoned decision making. We don't want to be ignorant when going into a project approval. And so that's the reason to make all this paper and analyze all these impacts is so that that way when the decision is ultimately made, we can make those analytic jumps, right? We can show the court why the facts met the law. We can not get challenged because we've done the appropriate analysis and made our decision based on the facts and the policies that we have at hand. So, any further questions?
So, Ethan, I remember hearing in a training program previously that this was CEQA was initially established under the Governor Reagan's administration solely for public works, and then it's evolved from then. Is that correct?
Yeah, I believe that is correct. And it kind of goes back to an era when, the environmental considerations were more bipartisan, I would say, and people were kind of concerned on both sides about what environmental impacts were happening. And like you said, it was really more geared at government projects specifically.
To protect the public from government projects that might be detrimental, right?
Right, and that's still the way. So under Nixon, the National Environmental Policy Act was passed, NEPA, right, which is what you'll get whenever there's a federal project as opposed to a local or state project. And NEPA is still, it's not just public works, but it's any federal project. And so, it is far more limited in terms of the level of impact it has on private projects that don't take any federal funding. If the private projects do take federal funding, then you have to do NEPA. And so, California has definitely legislated and increased the amount of scope and, the amount of environmental review that happens. And there's a really interesting, kind of comparative law issue between the states, right? Does CEQA make development and specifically affordable development more difficult in California compared to other states? And is there a middle ground to be found, or, are we protecting our best interests in terms of climate change and adaptation and planning going forward? It's a very rigorous debate. I don't know if I have the absolute answer. There's definitely more construction going on elsewhere, but whether that's a good or bad thing is kind of an open question.
Well, thank you very much for that very comprehensive report. Are there other questions from the commissioners?
I just have one final one because we were talking about what all the CEQA at the end, that end slide talked about, the goal of CEQA. And I was just wondering if anyone has a take between maybe like you and David on equitable development. And, if there are any policies or current legislatures or anything that considers like equity and development. So when you're developing, you can kind of be guided, like CEQA guides the environmental portion of it. But what guides, commissions when it comes to like making sure that one area isn't overly impacted or burdened while another area is underdeveloped and, things of that nature?
Yeah, it's certainly a big topic right now. People often use the phrase environmental justice, right, and how we consider where development happens and where impacts are located, and where we say that it is acceptable to approve a project despite its significant adverse impacts on the environment. Some cities, as part of their general plan, have an environmental justice element, right? It's not a required element of under state law, but some, bigger cities typically are starting to introduce this element, and then, that again, that's a policy recommendation, and then the city councils of those cities have approved those policy recommendations, and ultimately, as part of their general plan update, they need to make those considerations. But again, not required under state law, and I don't believe there's any pending legislation currently to make that a required element under state law. That being said, it's definitely there's potential for cities to incorporate that into their general plan if that's what their city council members decide is the best policy for the city.
Well, thank you again, and we look forward to your council as we progress along various other projects. Mr. Feinstein, do you have a director's report?
Yeah, and before I get to the director's report, just a few sort of closing comments. Lots of information there. Don't hesitate if you have follow-up questions. If you review the presentation, which we'll send out to you during the meetings as you're reviewing projects, as these issues come up. Again, don't hesitate to check in with staff, the city attorney, if you're unsure of where, how much authority you have, or if you want to weigh a certain condition or add a condition or make a finding, if you're not in support of a project, how you go about doing that. Again, the findings are going to be really the guiding component, and the findings that you're required to make are going to be in the resolution with your staff report. So always with the packets that are sent to you, read the resolution and particularly focus on the findings that staff has drafted for you to consider for a project. And that'll really be your guide, but don't hesitate to reach out to us with questions. So, directors, oh yeah, go ahead.
Can I just add to, every year we have commissioners training, and every year there are 2 or 3 sessions on CEQA. So
Yeah.
that's a good thing to keep in mind, coming up next spring, March.
Yeah, March is when Cal Cities puts on their annual commissioners conference, where you get lots of training like this, which leads actually into a great note for this commission. There is another annual training that is given every year during COVID. That actually got set aside for a few years. Sonoma State University puts on a commissioner's training session that really supplements the Cal Cities conference. Historically, it's been in December, first Saturday in December. However, I just got note from Sonoma State that they're changing the date, and it's going to be the 13th of August this year. Staff or the city is happy to pay for any and all of the commissioners to attend. It's on a Saturday from 1 to 4 over in Sonoma. Really great session. Sonoma State they've got a great planning program, and they put on just a really good training. So I'm going to send the commission tomorrow. I'll send you a link to that. Take a look at it. If you want to attend, just let me know. We'll sign you up. So that's one of the items I have for you. The other is we do not have any agenda items scheduled for your next meeting, although you'll close the meeting to the next meeting, which is the first Wednesday in August. But it looks like we're not going to have any items for that, but we'll cancel that officially when we make that final conclusion. But it looks like we're not going to have that meeting. But we do have items that are tracking for the second meeting in August, which is your fourth Wednesday in August. And we've got items coming as well in September. So we'll have some development projects. We will have a draft of the housing element of the general plan for you to review, provide any input to us on that, to have a public hearing in front of the public, to let the public provide some input. So that'll be coming up over the next month or two as we finalize that document. So although we likely won't have our next meeting, we've got a number of items tracking following that. That's my report.
Thank you. Any other items from the commissioners? If not, I will.
This is Commissioner Werblin. I do have a couple of items.
Okay, please go ahead.
Thank you. I wanted to personally welcome Commissioner Greavy and Paul to their first meeting, and we're so excited to have you on board. And our last meeting, I believe, was canceled, and we were going to have a housing update or a housing education, and I'm curious if that's going to be rescheduled.
Yeah, that was actually the item that our Associate Planner Jesse Hernandez presented. I can't recall if you were at the meeting, Commissioner Werblin, on the regional housing needs allocation.
Right.
I can send you a link to the video for that, so you can see that. But yeah, we had that item already.
We did, okay, I'm sorry, I'll double check, because I know I have not missed any meetings, but I thought for some reason I had it on my calendar that we were gonna have another education session on housing, but it could be my mistake, thank you.
Yeah, we'll have the draft housing element coming before you, but not another education on housing.
Okay,
But we'll
maybe
give you-
that's what was in my notes.
Yeah, as you review that item and in the staff report for that, there'll be quite a bit of background on housing law and things for you. So there will be some education with the housing element, but it's not a dedicated session on training for that.
Thank you. No further comments, thank you.
Thank you. Okay, we are now adjourned to our next meeting of August 10th, 2022.